Good evening, sir. My name is Ico Fulieros, and I will be discussing about Andano versus INC, dated November 6, 1990. The facts for this case are as follows. Missionaries of Our Lady of La Salette Incorporated, a religious corporation, built through its agents, water paths, water conductors, and water contrivances, including an artificial lake within its land, inundated and eroded the spouses Emmanuel and Natividad Andamo's land, caused a young man to drown, they damaged petitioners' crops and plants, washed away costly fences, endangered the lives of the petitioners and their laborers during rainy and stormy seasons, and exposed plants and other improvements to destruction. On July 1982, the spouses instituted a criminal action. And on February 22, 1983 of the next year, the spouses had issued a civil case for damages. The Court of Appeals affirmed the trial court's ruling and issued an order suspending further hearings on the civil case until after judgment in the same criminal case has been found. Spouses contend that the trial court and the appellate court erred in dismissing the civil case since it is predicated on a quasi-delict. So, the issue in this case is whether or not there is quasi-delict even if it is done on private property. The Supreme Court held that it is quasi-delict. All the elements of a quasi-delict are present, to wit, damages suffered by the plaintiff, fault or negligence of the defendant or some other person for whose acts he must respond, the connection of cause and effect between the fault and the negligence of the defendant, and the damages incurred by the plaintiff. While the property involved in the cited case belonged to the public domain and the property subject of the instant case is privately owned, the fact remains that the petitioner's complaint sufficiently alleges that petitioners have sustained and will continue to sustain damage due to the water paths and contrivances built by respondent corporation. It must be stressed that the use of one's property is not without limitations. Article 431 of the Civil Code provides that the owner of the thing cannot make use thereof in such a manner as to injure the rights of a third person. The Supreme Court also dictates Article 177, which is responsibility for fault and negligence under the preceding article is entirely separate and distinct from civil liability arising from negligence under the Penal Code. But the plaintiff cannot recover damages twice for the same act or omission of the defendant. Whether it be done by conviction or acquittal would render meaningless the independent character, the civil action, and the clear injunction in Article 31, that his action may proceed independently of the criminal proceedings and irregardless of the result of the latter. That's it, sir. Thank you so much.